What's up, everybody? We're at it today, and whatever they're calling it, Crime Super Tuesday or whatever. A lot of hearings going on. I haven't seen anything from the Sarah Boone case. I assume that trial is getting continued, so not a ton to break down there. We did get a video from a number of you about a juror that has been thrown in jail in Florida. No, it is not any juror connected with the Maya case, but you can stick around, and after this video, if you turn on your autoplay, you'll be automatically redirected to that video that I recorded earlier this morning. But the main event today that we knew was coming was this hearing on Murdaugh. We have a brand new judge who's a former justice of the South Carolina Supreme Court. Big shot, knows what she's doing, no fear of anybody, which you could hear. Not afraid to make a call, not afraid of what anybody's going to say. And we're going to hear what she thinks about the case so far. We get some interesting insights from her rulings and her comments throughout the case. The beginning of the hearing was a lot of each side making the same arguments we've read multiple times in documents, so we're not going to go over every single argument. We're going to go over kind of the end of the first part of the hearing, which was what is the burden, who has to prove what. We're going to get the judge's ruling, and then the majority of the time was spent on what the procedure will be. Because while there are arguments made on the record by the state that maybe there shouldn't be an evidentiary hearing or interviewing these people, everybody basically knows at this point we're having the evidentiary hearing. But the first big question that was before this court is, what is the burden and who has the burden? So that's where we're going to jump in. Don't forget to like the video if you guys haven't done that already. And please subscribe to our channel. Don't just watch the videos, but subscribe. It's one click. It helps us out. And we are so appreciative when you do decide to do that. I have boosted the audio, and we are going to watch this hearing together. This first clip we're going to watch is about, I don't know, what, 5 or 6 minutes? Yeah, the first part with some short arguments, and then the judge's ruling on the burden, and then we'll jump to the big ticket item. Also, stay tuned because we hear from Eric Bland and Ronnie Richter. We hear about the nefarious allegations for Becky Hill and what the judge thinks about those allegations, and whether or not we're going to hear more about them in the hearing.
Difficulties with his wife and that sort of thing, clearly external information. And again, the court held that the defendant failed to show prejudice. So the case law in South Carolina, both from our state Supreme Court as well as our state court.
All right. Creighton Waters is already too fast for 1.5 speed. I don't want to hear the complaints, so we'll bump it down to 1.25. We got a lot to get through. If you want to slow it down even further, you can do it on your stream as well by hitting this gearbox and playback speed, whatever you want, 0.75, 0.5, however slow or fast you'd like to listen to it.
Appeals, it's clear, it's in sync, it's uniform, that is the defendant's burden to show prejudice, and that's, of course, only after there's a determination that any sort of extraneous influence occurred, and that would be the state's position, that it is the defendant's burden. And again, we can address at the appropriate time what the state's position is as to the order of which the evidentiary hearing should go.
Thank you, sir. Mr. Griffin, can you reply?
Yes, Your Honor, there is a tremendous difference in the law as to how the court analyzes juror misconduct, as in Kelly, where the juror reaches out to her pastor, gives a pamphlet, brings it into the jury room, and that was found during the course of the trial. The trial judge removed juror O, who had gotten the pamphlet, board every juror to ask what effect that had, and if they could put that out of the mind, and then deliver it. So that happened during the middle of the trial, but it was juror misconduct. All the other cases that you cited in the state relies upon are juror misconduct cases, not unauthorized third-party communication that goes to the heart of the Sixth Amendment, right by a defendant to confront his accuser, to cross-examine witnesses and present evidence. And when a third party makes an improper contact with the deliberating jury before they deliberate, that falls at the heart of the Sixth Amendment, which is a different animal altogether than where a juror engaged in misconduct. And that's where you get to Cameron. That's where you get to Green, which Green says it was a procedural communication, not a merits communication. And Your Honor, in Bryant, well, I wouldn't know, Your Honor, percent detail, but in Bryant, I mean, no jurors were interviewed, as best we could tell by the record.
Basically, he says Waters just talked about all these other cases that deal with juror misconduct, not outside tampering with a juror. And Waters responds by saying, yes, I did, Judge. Here are the cases that were outside influences with jurors. Again, a lot of these hearings or a lot of these arguments we already heard. The big thing we want to hear today is the judge's decision.
Since that case in 1993, there have been several cases, including Green, Oliver, and others, that very specifically talk about this issue of what the burden
Somebody asking for closed captions. They don't have it available on this video, but I think you can turn it on my video on your end.
is on a motion for a new trial on the basis for after discovered evidence that involves tampering or alleged tampering with the jury. All those cases say that prejudice must be proved, not presumed. And it may very well be that that is what's going to be shown. But for purposes of what the defendant must show as the case goes forward to the evidentiary hearing, the presumption simply by the contact, which we don't have any sworn evidence about except in the area of one juror at this time. A presumption is not the way to examine this issue, but rather specific evidence about what was said, when it was said, and how it was perceived by the juror is what I believe is required by State versus Green and other cases. And therefore, that is the approach I will take. All right, the next area.
Burden on the defense to show the prejudice. That is the stance the judge is going to take. And then now we will jump forward to what the procedure will be when discussing who they will be allowed to call as witnesses. Will it be an open court? Will it be behind closed doors? Will it be in camera? Will the judge ask the questions? Will counsel ask the questions? Will counsel for the jurors be allowed to ask questions or participate in that hearing? All of that and more now is kind of the big chunk, the next 20 or 30 minutes of the hearing we're going to listen to together. There was some other interesting discussion about the Facebook post and what Miss Becky said behind closed doors that the lawyers heard and to Judge Newman. But we're going to focus in here on this procedure because this hearing is happening on January 29th. Later on in the hearing, Harpootlian actually asked for a continuance, so we'll hear why later. But for now, what is that hearing going to look like? Who's going to testify? Who's going to ask the questions? All of the important things that we need to hear what the judge decides on.
During the deliberations, it said that the court said that. Did she discuss that with any other jurors? Did she infect the jury? Does this allow you to do that?
You certainly, if you go to 606B, it gives you some guidance about that. It says, an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind or emotions influencing the juror to assent or dissent from the verdict or indictment or concerning the juror's mental processes, except a juror may testify on the question whether extraneous, prejudicial information was improperly brought to the jury's attention or whether any outside influence.
It looks like he just looked back at McCullough, the guy with the longer white hair who's representing one juror and one excused juror.
Was improperly brought to bear upon any juror, nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which juror will be precluded from testifying be received for these purposes. I take that to give us the guidance we need about the parameters of the questions.
But if the juror that gave us the affidavit, would she be asked, did you discuss that during deliberations? Did she do that?
But that apparently is very questionable under the terms of 606, and I intend to abide by that. The way those
We're
questions.
discussing what kinds of questions can be asked, what can't be asked. We don't want to get into the jury's mind on why they made the decision that they made. Murdaugh's team doesn't want them to because they don't want to have to actually show it would have overturned the verdict. Because they think probably the jurors are going to say, no, this wouldn't have changed the verdict or changed my mind. But Murdaugh thinks that goes into things that are supposed to be protected from the jury. I don't really know where I stand because I can read kind of the case law and the rule on both sides and kind of see where the judge would rule either way. And the judge says it seems like that's arguable at this point. So we'll have to kind of wait and see how deep they're going to be able to dive when asking these jurors questions.
questions have been asked in many cases I have reviewed, is to ask the juror whether that's still their verdict. If they ask about improper contacts and they talk about improper contacts, then the way to pursue it beyond that for the judge is to ask about the impact on the verdict, not on the deliberations themselves. That may be a small slice of difference, but I think it's very important to understand that no one, not myself or anyone else, is going to be asking the jurors about the specifics of their deliberation. The rule is quite clear about that.
Okay.
So we're quite clear. Nobody's going to ask the jurors about the specifics of their deliberations. And lawyers, judges are lawyers. This judge is a lawyer. They've got away with words, right? No one's going to ask about the specifics. You better not. It's like, well, that's kind of the point I'm trying to figure out. Is this specific or is this general? Because you said specific. So if I ask a general question, am I allowed to do that? So there are these gray areas in the law that are really where most of the work is done.
And is it clear that you will not be using the SLED interviews or MOIs to attempt to impeach?
I told you when that was brought to my attention in our Chamber's conference this morning, I have made my mind up about that. I don't know what's in those summaries or anything else, and we're going to have to discuss that. But again, I'm the one who's questioning at this point, Mr. Harper.
Yes. Yes.
And I'm trying to see what you all are asking. I'm going to go to the state now and see what their reaction is to what you said.
Thank you, Your Honor.
Mr. Waters?
Thank you, Your Honor. May it please the court. Your Honor, again, we would concur with what Your Honor just said about Rule 606 and, of course, all the cases that we've talked about and the need to show prejudice. And obviously, when you're talking about external influence, that prejudice, which will be an appropriate subject of inquiry to the jurors, is whether or not there was an impact on the verdict. And we, of course, have suggested to Your Honor, not only based on the cases, that should be judicially conducted in a manner that protects the privacy of those jurors and that protects the privacy of their identities. These jurors, were drafted into service, and this inquiry, of course, has to happen, but it needs to be conducted in a manner that respects their privacy and should be, of course, judicially conducted. We have suggested those two questions. If we look at the Bryant case specifically talked about the fact that depending on how the examination goes, there could be questions suggested by the parties. And obviously, I think we would need to cross that bridge if and when that bridge needs to be crossed. And that starts with the court's inquiry to those jurors. And only if something arises that needs further inquiry could that be addressed at that point. And that could be even a discussion from counsel with the court as to what additional questions may be proper. When the state first became aware of these allegations, the first thing that we did was have SLED do an independent investigation. And the goal was, good, bad, or ugly, to get to the bottom of what, if anything, happened. And the result of that is why we're still here today.
Good, bad, or ugly. They just want SLED to be honest. And yes, Creighton Waters just talks fast. Okay. He just talks fast. It's the same speed everything else has been on. Some interesting questions here. Hi, Peter. Loving your commitment to so many cases. Fantastic effort. Stay safe. God bless you and your family. Thank you so much. Cat Mom said, is this judge supposed to be a female? I'm confused. It is a female judge. Yala said, Peter, will you admit you were wrong about the prejudicial effect being necessary for granting a retrial? This is what's so great about the law, Yala. Peter, will you admit you were wrong? Here's what I will admit and what I will say. The judge seems to disagree with me. I'm still interested to see how it all comes out once the evidence comes out and how far she is going to take this kind of prejudicial effect ruling. But that's the point of the law, right? There's a statute, there's case law. Lawyers think differently on each side. They argue it and the judge makes a call. It doesn't always mean one lawyer's wrong. It means he didn't win the day or she didn't win the day with their argument. But yes, it seems like the judge is leaning more with the prosecution on what needs to be proven in this case. It also seems like the judge is leaning much more with the prosecution as to what evidence she's going to allow to be presented in this evidentiary hearing. I find this to be very interesting. And again, I do not agree. I agree with a lot of her rulings. And I think she's decisive. That's my favorite thing about a judge, is to be decisive, whether or not I agree with them. But there are a few rulings I do disagree with here, and I don't understand how she's coming to this conclusion, but she's the judge, and she is. Carrie, Peter, this may be far-fetched. Any chance this was all set up with Miss Becky from the defense to enable a retrial in case the first trial was lost? I would be shocked that she would open herself up to this to help out the defense. Bev, Judge Toll, the hearing will remain focused on Miss Hill's impact on the verdict. Harpoolian, but Your Honor, the dismissed juror's cousin's husband said Murdaugh is guilty. Judge, zip it, Poot. More of this coming later. More of this coming later.
And that is that in speaking with the jurors that spoke to us, that the balance of the evidence, as well as in talking to the clerk staff, was that there was no impact on any verdict. There was nothing unprofessional or untoward that happened that had any effect on the verdict. And so when we did that inquiry, and that is what the jurors said, that is why we're here today, and that's what this hearing is going to address. The only juror that we have is the one who filed the affidavit. That's 630, and even she, or that person, only said that she, eventually voted guilty because she felt pressured by the other jurors. Did not even mention any external impact. And so unless she's going to change her story, that is what was in her affidavit. So the balance of the evidence is the reason why we're here today, and why this hearing needs to take place. Your Honor, as far as inquiry to those jurors, again, there could be a need that the parties would suggest questions, and it could be, depending on how things go, that the affidavits or maybe even recordings, all of which have been provided to the defense, full recordings of those interviews of any potential witness in this case have been provided to the defense. It could be that issues could arise from either the state or the defense as to impeachment, and we can address those issues as they arise under the appropriate rules, 608, 613, and the like, dealing with not only prior inconsistent statements, but other evidence that would be properly impeachable. Ultimately, I do need to address one thing as it deals with all of this, and that is the defense's contention that somehow the clerk is a party opponent in this particular case, and we believe that that is incorrect. Obviously, there is a hearsay exception or a non-hearsay determination in the evidentiary rules, I believe.
Yeah, and again, I agree with the state here that Ms. Hill is not a party opponent. I think there are some interesting arguments the defense made and could make, but that's the whole point. She's not a party opponent. She's an unbiased party. She's somebody in the middle that shouldn't be on either side. So I don't think the same rules and exceptions to hearsay should be afforded to them with what Miss Becky said. But where I agree with the defense is I think they should be able to ask her about more than this judge is going to allow her to ask. So this is kind of a situation where I see it on both sides where they should be limited. I do not see her as a party opponent at all. I do not see her as a member of the prosecuting team or the state, even though she's a government employee. But I do see a lot of context around the questions that they may ask her that Harpootlian is going to get into in some of his argument.
One that excludes statements of a party opponent, but just because the clerk is an elected official and of the state, that does not make them a party opponent in the way that term is defined. A party opponent is an active litigant before the case, and that is, I think, a difference. So we would certainly say that the hearsay rules would still be in effect as it relates to Ms. Hill and any testimony that she may
I agree with
provide.
that.
I know there's been some discussion about the order in which the witnesses may be called and whether or not Ms. Hill would be a hostile witness, and obviously that's under Rule 611 arguments at that time. Your Honor,
whether or not she's a hostile witness, we'll see when she's on the stand.
In looking at the type of examination that would need to happen here, and again, the issue also arose of the Fifth Amendment. And I know that the defense would like to brief that issue, and we're happy to respond. We don't know exactly how that might arise in the course of any examination. We need to cross that bridge again when we get there. We would say, though, that the Fifth Amendment is question specific. And so, again, it may be something that this court has to rule, as in any sort of evidentiary presentation, question by question, based on any objection by the court.
I agree with them there as well.
So it's kind of hard to say that exactly what the blanket position would be until we actually get to that determination. Ultimately, the defense referred to some information provided this morning. Actually, both sides exchanged last night their communications with the clerk during the course of the trial. So both sides did that last night, and there were a lot of communications with the defense as well. And so again, I just want to point that out in the that there's any sort of allegation or insinuation that the state's not providing information. We've been very diligent about providing any and all information to the defense, and if any additional information arises, we will continue to do so. But both sides exchanged that last night, and of course, there's been some reference in their filings as to emails that were forwarded from the clerk to me and to my paralegal, and they've actually even listed me on the witness list. And Your Honor, as we have had a chance to peruse the defense communications with the clerk, there was just as much communication and offers of help. It was just a uniform across the board courteousness that's reflected from that.
So very important couple things. As we said, I wonder if we're just seeing part of this from these FOIA requests, and if if Ms. Hill was just kind of corresponding with everybody. And the AG here, Creighton Waters, says, the assistant AG, I should say, that there was communication going both ways. So if I'm going to be a witness, they're going to be a witness. But I'm going to play this here with no sound as he says that again, and check Harpootlian's response. There's just as much communication with them and us, and he just shakes his head and kind of scoffs. Jim Griffin as well shakes his head no. So they do not agree with that representation. And again, these are the kinds of things that have to happen. These are the kinds of things we have to make a decision on. We have to hear the actual evidence. The judge said a million times, I don't know that yet. I don't have that information yet. I have to see what these people say. So a lot is still to be determined here in this hearing and in this entire situation.
It's a non-issue, and we think that should not be something that arises during the course of this evidentiary hearing, at least as it would require communication from or testimony from attorneys. Your Honor, ultimately, as we look at the inquiry that will need to be conducted, as the state has made clear, it starts with the jurors. And only if something arises in that inquiry, further inquiry to those jurors may be necessary. And that could be in discussion with the parties, as I've stated before. And then the state would have objection to some of the information I believe the defense would propose to examine her on. We believe that an inquiry should be limited to what is appropriate and relevant impeachment, but not should be just a far-ranging fishing expedition or full inquiry into a lot of subjects that have come up since the trial that we believe are not relevant to any inquiry that is before the court.
So they want to limit what the defense should be able to ask Ms. Hill about. The judge has some thoughts on that as well. So we'll reserve our thoughts until we hear from the judge.
Here now. Obviously, rules 404, 401, 402, and 403, as well as, which of course address relevance, and 403 objections, 404, which addresses other crimes or wrongs or acts.
I'm going to skip ahead here because we're going to get the judge's ruling on a lot of it.
Particular proceed from there. And
404, I did somewhat.
This was kind of tongue-in-cheek here by Harpootlian, and a lot of people love or hate that he does stuff like this, but he's about to get into 404 type of evidence with his other similar bad acts and why or why not you can't bring them up, and he's going to call Creighton Waters the expert on this specific exception.
Ironic. 404, I did somewhat ironic. State is quoted Rule 404, Your Honor. One of the exceptions to 404, I know this would be surprising to Waters, is motive. You've never heard that before. He told me this morning one of the assistants that worked for Ms. Hill during this trial was told by Ms. Hill during the trial that a guilty verdict would be good for sales of a book. Motive, selling books. So we believe we should be able to get into that. We should be able to ask Ms. Hill about it. If she denies it, to call that witness, that assistant, and have her testify that she was told that. I mean, why would a court do what we allege she did? We think is important for Your Honor in terms of credibility and context. That's number one.
So the judge later, when he mentions this again, says, I don't want to hear that again. And what's really interesting about this is they want to prove wrongdoing on the part of Ms. Hill. But what's kind of just interesting to me is if you look at it from the judge's perspective and she's saying, listen, you got to come in here, you got to prove that there was contact with the jurors and that it was prejudicial to the defendant. And what Becky Hill's motives for contacting or improperly tampering with, whatever you want to call it, if it's true that she did do this, are her motives really important? Do we really have to prove her motive? Now, it's a nice narrative. It would help prove wrongdoing if this was a criminal case and we're trying to prosecute Becky Hill. But for why we're here right now, jury tampering, did this prejudice Alec Murdaugh? Does Becky Hill's motive matter? And while I think it adds to the credibility, it adds to the argument, it makes people believe more that this did happen, is it actually an element that's necessary to argue for this motion in this hearing? And the judge eventually says no. And we're going to hear that from the judge.
Number two, Your Honor, I think we all agree, you're going to ask the questions, whether we agree or not. And we do agree with that. The question is going to become, as we go through that process, how, if a juror says X and they said in their interview Y, or if they said to us Y, or didn't include it in their original affidavit, and you don't ask that question initially, how are you going to handle, or do you care, how we suggest to you a further question? Because as Your Honor's seen this morning, the back and forth can go on for a while, and we certainly don't want that to go on.
She complained about that a couple times.
So we're going to need some guidance on that. I'm not expecting that guidance this morning. The last thing is, as these jurors are examined, I need to understand a little bit about the logistics. Are we going to do it in this courtroom? Are we going to do it in another courtroom? Is the public going to be able to hear the responses? Will it be an audio feed if we do it somewhere else? Are you going to have cameras turned, do it in this courtroom, have cameras turned off? And we're obviously.
So she answers all those questions a little bit later on, but Stevie said, goes to her credibility. I agree with you, but, let's say they prove she talked to the jury and she tampered with them. Does the reason why she tampered with them matter? And like logically thinking and just in a layperson and how we think every day, of course, motive matters, the reason matters, the purpose matters. But in answering these questions before this court, does Becky Hill's motive matter? Not so sure it does. I'm glad to know it in our discussions and for what I think is happening in the background and whether I think there needs to be a new trial in this case and all of the smoke around it. But I'm not so sure for this specific question that we need that answer. And it's just an interesting thought exercise here that's happening before our eyes.
Actually, not to refer to jurors by their names. Even though 3 of these jurors went on the Today Show, another one went on ABC, they were all in the courtroom.
There's a lot of discussion about the anonymity and whether or not we're going to say these jurors' names and show them, but the judge is going to tell us about that procedure later, so I'm going to skip ahead a little.
I tend to ask the juror. This is all right. With respect to the jurors, first as witnesses, I will be doing the questioning of the jurors, and I will notify the parties pretty promptly what I intend to ask the jurors.
So she's going to question the jurors. She's going to let them know what questions she's going to ask. They can submit other questions if they want to.
The ambit of what I will be asking them is informed by the question of whether improper contact was made with them and whether it affected their verdict. I understand that you, on the defense side, have views about what further should be asked the jurors on 2 levels. One, as a predicate to what you want to do with the clerk herself in examining her. And 2, as a means of further attacking the credibility of the clerk in her testimony.
This entire thing gets a lot harder for Murdaugh when he has to prove prejudice. So that's going to be a really interesting line of questioning. What is the judge going to ask? What are the follow-up questions going to be? That's going to be really interesting. JM said, Peter, can Becky plead the 5th? The state says yes. The defense says no. I lean on the yes side. And I think it could be very helpful for the defense, for Murdaugh's team, if she does plead the 5th over and over again with some negative inferences. Gringa said, thankful for the delayed stream out here in the PST. Thankful for you being here in the different time zones. And Netwoman gifted 20 Lawyer You Know memberships. That's awesome. Let's get them in here before our second January Members Only Live, either coming later this week or next week.
I have not seen any of the SLED material or memoranda concerning the state's summary of these interviews and so forth. I will be open to receiving that if it's done promptly, because we've got a hearing coming up the 29th, and I want there to be plenty of time to revise any current ideas about who to subpoena, who to call as witnesses, and who has to do that. But I can tell you that I am very, very reluctant to turn this hearing about juror contact into a wholesale exploration of every piece of conduct by the clerk alleged to have been improper on its own, indicative of her characteristics, her personality, or anything of that nature. This is a very focused inquiry that deals with this jury and what impact contact, if any, had on this jury. So I am very mindful of the limited nature of it. As I say, I'm not excluding submission in advance of information that would take the questions beyond the limited questions I've initially indicated.
So what she's saying here is you will focus on the jurors. You won't focus on the books. You won't focus on the wiretapping. You won't focus on anything else with Becky Hill. You will focus on the jurors and the conversations that she had with the jurors and whether or not they changed their verdict based on what she said.
But I will be very hesitant about any of those questions as it involves propounding those questions to the jury. As it involves questions to Ms. Hill similarly, this is not the time to explore every mistake or incorrect statement or false statement that ever has been made by this witness. I am a judge of the credibility of this witness for purposes of this new trial motion. I don't think it's necessary, nor do I think it's proper, to explore each and every impropriety alleged to have been committed by the clerk. At the same time, what specifically should be asked is something that I will look at as I look at the submissions that are made before the hearing takes place about what is requested to be allowed as topics for questioning of the clerk and what exhibits should be. I can't imagine allowing thousands of emails to be made exhibits in this process. Either emails sent by her to attorneys in the case, to other court officials in the case, or to other individuals during the course of the trial of the case. I certainly will try to preserve the appellate posture of defense in this regard, but I will put certain limitations on just a wholesale exploration of every problematic piece of conduct, ethical dealings with the county, and so forth. This is a very focused inquiry about this jury and its ability to render the.
So I do understand some of this, but I don't like putting a limit on the number of emails that might be relevant or might be proper impeachment material, right? Just because there's a lot doesn't mean it's automatically wrong, but it does. Basically, the point is everything's going to go through scrutiny. Who's called, what exhibits, what emails, if it's appropriate, if it makes sense, if it's relevant, then it'll come in. But she's not just going to say yes to everything or no to everything at this point, but she is definitely going to focus this hearing in on specifically what needs to be proven for the jury tampering allegations.
The verdict it rendered in an impartial manner. So I say that to tell you that when the clerk is offered, and I think the clerk is going to have to be offered as a witness, the whole allegation revolves around the contention that the clerk made contact with the jury about matters material to their verdict, that contact was improper, and that it impacted their verdict. There's a whole lot more that.
That's the point. Those are the three elements, right? Did she make contact with them, Becky Hill? Was it improper? And did it impact their verdict? Not what was her motivation. Not how did she want them to vote? That doesn't really matter, right? It's was their contact, was it improper, and did it affect their burden? I don't agree that that is the proper analysis, but I'm not the judge, so it doesn't matter. What I think literally matters, squadoosh. And we'll talk about it a little bit more. Hopefully I remember at the end, because I know we still have a lot to get through on kind of my thoughts on where I'm at and why I feel that way and what I think the outcome is going to be and if I agree with it. So, I mean, there's a lot still to get to, but hearing this judge was kind of the point of getting to this hearing.
Mr. Harpootlian has indicated he'd like to explore that I regard as totally extraneous to the inquiry that we maintain. I'm not going to allow those questions to be asked by way of proffer and then have the clerk answer those questions and have that be the proper, although I consider them irrelevant questions. We're not going to handle the case in that way. If I exclude a certain question from being asked, then the proffer will be whatever in writing is chosen to be offered in that regard. But I will not.
So she's also saying she'll let them kind of perfect the record with proffers. So Michelle, I disagree, Peter. I believe that is only relevant if more is needed. I agree. I don't think we're disagreeing on what's relevant. I'm saying I'm disagreeing with the analysis the judge has. I think she's applying the cases the prosecutors gave her to apply, but I do think it's different when it is a government personnel who makes these comments to jurors. I would agree with the line of cases the defense cites on that specific issue. And so, I mean, that's kind of where we might disagree, not necessarily on what's relevant, because I don't think they should necessarily be able to get into everything, but what the analysis is and whether or not they have to show that it actually would have changed their verdict or it did affect their verdict.
I conduct a hearing, but there's a whole side hearing in which every question desired is asked and either required to be answered or dealt with some other way. I don't think that is an appropriate use of this very targeted hearing that I'm directed to have. I also think it makes a great deal of difference whether the questions that are being asked relate to the clerk's conduct at the time this case was tried, as opposed to other conduct at a later time or in connections with other things than the trial of this case. So I will be looking very carefully before we conduct this hearing and trying to give the parties as much advice as I can about what I would find to be acceptable topics to pursue. I think you're entitled to that, but I also think the record of the case is not to be used as a platform to explore each and every fault of each and every witness, whether it be the juror or
This is not your opportunity to prosecute her, Mr. Harpootlian, is basically what the judge is saying.
clerk. And I'm not going to have a hearing conducted in that manner. I think there are other ways of preserving topics that I rule should not be pursued than having those questions asked and answered, even though I rule that they're not proper in the hearing. So I hope that explains kind of where I am on the subject of how questions are asked.
So that's where the judge is on how questions are asked. Kat, Peter, if the judge does not grant a new trial, does the defense have any further recourse? Is the appeal the only thing left? Yes, then they'd have to appeal it up to a higher court. Ashley, what can Alec Murdaugh do to fight having to prove that it would have changed the verdict? So he can either ask them, and if any of them said it did affect their verdict, then that's good for him. If they don't, then he's going to have to appeal it to a higher court that this judge used the wrong analysis. John, Becky's motivation may not matter, but what if her motivation made her act inappropriate during the trial, decorum? So that's not one of the questions. The question is, did she have did she have contact with the jury? Was it improper? And did it affect their verdict? And that's why a lot of these questions that are going to come in the future, we've got to apply that analysis and see if our answer would be different than if we were going to apply the analysis that we discussed earlier. Lawyer, can the judge deny a new trial since they didn't file in a timely manner? She could have, but it seems like the state didn't really push that too much. And the judge said, I'm not going to rule on that. The lawyer said, Judge, we swear we didn't know about it beforehand. And the AG's office is like, well, we'll believe what the lawyers are saying at this point. So it doesn't seem like that's going to be an issue. Joanne, with all the new members, we will need a bigger fantasy football league next year. Netwoman will be the commissioner. And maybe we'll do 2 leagues because we can't go too much bigger than 14, maybe 16 teams. Netwoman, in your opinion, do you think any of this would have come out if she hadn't have written the book? Also, is Becky on paid leave? I do think the book was a huge motivation for this and all of her interview. I'll kind of put all of the publicity that surrounded Miss Hill post verdict. Gosh, there's like a fly here and it's annoying the crap out of me. So I do think that had a huge part in all of this coming to light. I don't know if she's on paid leave. I'm pretty sure she hasn't been like just flat out fired at this point, but I'm not sure if she's on paid leave. Somebody else in the chat might know the answer to that. Diana said squadoosh. Yep, squadoosh. Bev, my non-lawyer gut disagrees with Judge Toll's ruling, but she was having none of it. And I'm over here with my popcorn. 129 can't get here fast enough. Yeah, I assume most of the public is going to love these rulings because all of these rulings makes it a lot more difficult for Alec Murdaugh to get a new trial. A lot of them sound like many of the appellate court lines for criminal appeals, which is you got to prove this was going to change the verdict. Because if it's just some harmless error, we're not going to do this all over again. So we're going to have to wait and see if that continues once we find out what comes out in the hearing. And thank you, Love, for gifting 20 memberships. That is awesome. It's a good live to be in. Lots of memberships going out.
Some of the suggestions that are made and the findings you made with me about the additional witnesses you'd like to call and subpoenas. I think
So they take they're about to take about a 20-minute lunch break or, comfort break. And then we're going to jump back in right here. And okay, so here's where the judge is going to tell us how are these questions going to be done? Behind closed doors, closed courtroom, in camera, in chambers, or in open court. Let's get our answer here.
look at how this is to be questioned. In open court, how the jurors will be questioned. Everything will be done in open court.
Open court. The jurors will be questioned in open court. Now, there will be some protections. Court TV won't zoom in on their face. later, some of the lawyers ask for their voices to be muffled. We'll talk a little bit about that. But open court, public. South Carolina likes the public to be able to partake.
The jurors will be referred to by number. The court TV cameras, which are the ones used to film these proceedings, will not be allowed to focus on the image of the jurors as witnesses. And if there's some need to further obscure the way they are presented, we can talk about that. But they'll be examined right here in the courtroom as other witnesses would be. And I kind of looked at a little bit of exchange we'll have with attorneys for the jurors to see what we can work out about exactly how the jurors are presented. But everything will be on the record here in open court, with measures taken to ensure the privacy of the jurors.
I'm a little surprised at that. But that's how this judge wants to do it. If I was a juror, I'd probably ask for it to be closed court, and their lawyers, we're going to hear from them later because some of them are going to come and talk to the court. They kind of ask for a little bit more anonymity and a little more secrecy. But at this point, everybody in the gallery, everybody from the public that wants to come sit there and watch is going to see their faces and know who they are. I hope they don't do anything stupid with that information. But really, the only privacy is going to be court TV won't show their faces when they're testifying.
No
You just
further-
imagine if you were the verdict or if you were the juror in South Carolina that did or said something or something happened to you that now Murdaugh gets a new trial. I feel like they would be in fear for their safety. And I think the defense is afraid that they're going to maybe be a little bit scared to say certain things based on that. So it's kind of it's an interesting thing that's setting up here.
Acts would be permitted of the jurors or anything of that nature. And I believe if I announce that in advance, the press that are present, the press that have covered this proceeding throughout have been respectful of the judge's request, and I'm very confident they will be in this matter as well. With respect to the alternate jurors, I will question only the jurors who sat and considered this case. So the alternate who was dismissed by the trial judge. That alternate did not participate in any way.
That's a bombshell right there. The judge will only question jurors who sat and made the decision in the case. Egg lady, out. Alternate jurors, out. So that's huge because a lot of that is the corroborating testimony to what Miss Becky was doing and what they heard. Also potentially impeaching to some jurors that maybe said Miss Becky didn't say anything. But if we're doing the analysis the court has put forth as the burden and analysis to be done in this case, I think she's right. So I don't agree with her analysis, which again, I don't agree with this. I think that this stuff is relevant and should come in. But because the judge made decision A, decision B, I believe is correct. Because if your analysis is, did Miss Becky talk to the jurors or have contact? Was the contact improper? And did it affect their verdict? If you did not render a verdict in the case, your testimony, the contact with you, what happened in this case is not relevant for this analysis. Every action has a reaction, right? And when you go down the line in analysis, what the burden analysis, why it was so important, affects all the other decisions.
In the deliberations about this case, there's nothing that's been brought to my attention about anything the alternate might have done that was improper at all in terms of communications with fellow jurors. Nothing's been alleged in that regard. So our focus will be on the jurors that heard this case and not on either that alternate or any other alternate juror that has been proposed for questioning. I will not permit that. With witnesses or testimony, I do not allow. Let me explain about proffer. Proffer will be a written proffer by the party dissatisfied with the limitations of my ruling. But there will not be some examination as to proffer. The proffer will be a written proffer by the attorneys in accordance with their positions about witnesses and testimony. With regard to the subpoenaing of witnesses, the parties should subpoena these witnesses, and the state would issue of witnesses. Bishop's position
We don't really
of
care about the
defense was
process
that only
getting witnesses at this point.
if the parties
We already talked about proffers. They could do it in writing or in open court, tell the judge what would have been said or done for the record, but she's made her rulings.
can't agree on measures the report to recite their testimony. And then when their testimony was complete.
So I want to jump ahead just a little bit so we can hear when Harpootlian gets up and says, Judge, are you sure we can't call the egg lady or the egg juror?
I think that covers it at the present time. So the first thing I'd like to do is to get some clarity from the attorneys as to what furthermore, for the parties, as to what furthermore needs to be discussed. And then after that, we'll explore with the attorneys for the jurors and the attorney for Clark
I noticed
Hill,
this too in that one.
any other issues that still need to be developed. Mr. Hopkins.
Please support, Your Honor. I'm trying to make sure I understand what you just ruled. Are you ruling that we cannot call the alternate juror or the so-called egg lady to corroborate what was said to the sitting jurors, since they were all told this at the same time?
I'm not sure I understand your question, but I'm telling you that I want these jurors, these alternates would be called apparently to testify as to what the clerk said.
Yes.
At the present time, I see no necessity for them to be called to say what the clerk said, because we're talking about what the clerk said to the remaining jurors, those who actually sat on the case. The corroboration is something I don't think I need at this time. I think I'm perfectly capable of evaluating what the jurors tell me, and I'll do that. I think I'm also perfectly capable of evaluating the credibility of Ms. Hill and the jurors for that matter.
Well, Your Honor.
And Emma said, I think the judge will allow a hearing, but has already made up her mind and decided no to a new trial. It's what it feels like, right? It's what it feels like. You guys are getting the hang of this. When we watch and listen to a judge, you can always tell where they're leaning. I should say, usually you could tell where they're leaning. Pesky Pirouette says, now I want to be a juror even less. Cat Mom, aka Vicky B, said, don't they say motive doesn't have to be proven in other trials? Why should it matter in this trial? So no, motive doesn't have to be proven, but evidence of motive is relevant and is allowed to be presented. So that's why they were trying to use it. They're saying, we think motive is relevant here and we should be able to prove it, but the motive doesn't matter and they're not proving it to a jury and it's not something that's relevant here to the judge. That's what the judge is saying. So yes, motive is not an element, but a lot of times evidence that may not otherwise be relevant can be relevant to prove motive. So it can actually come in as an argument in trial. If a new trial is granted, will he move to federal prison? I think he will stay in state prison while he awaits state trial because he still would be held there awaiting trial for these murder charges. Ashley, did Becky Hill help to get Egg Lady kicked off though? Technically, according to Judge Newman, it had nothing to do with the Facebook post or anything Becky Hill said. I don't know. And again, I think that that's fair game for the defense to argue that her actions did affect the outcome because she was removing jurors or helping remove jurors that she thought might not vote the way she liked. Or she wasn't as sure they would vote the way she liked. And that's more than just, did it affect an individual juror who did vote's outcome? Because overall, if she affected the makeup of the jury, that affected the outcome. So a lot of nuance here. And that's why, my opinion, the more appropriate thing is, did the clerk of the court have improper conversations with the jury? And was it about substantial, material things going on in the case, like the defendant, the defenses, the defense attorneys, and the arguments? And if the answer is yes, I do not see how we can ever call that a fair trial. That's just my opinion. And I would hate it if it was my trial. I would hate it if it was my loved one, my dad, brother, mother, aunt, wife, in the situation where the clerk of court was doing things like this. I think it's despicable. But as in many criminal cases, if the jury says, nope, we knew he was guilty regardless, then that is what it is. And it's unfortunate sometimes. I know a lot of people want Alec Murdaugh to go down, and guess what? He's going down. He's going down no matter what. He's already pled 20 plus years with maybe more to come. So he's going down. Let's do it the right way, because I want him to go down too for what he's done and what's proven that he's done.
For us to, and then you said you wouldn't allow a proffer of that except in writing. Now,
Yes, I'm not gonna have a courtroom proffer of any kind. If you want to proffer, what would be offered by means of affidavits, copies of emails, anything else you want to, that's fine. But I am not going to have a courtroom proffer, no. I think the only reason for the proffer would be to preserve your right to appeal. I believe your right to appeal, my rulings will be perfectly preserved, frankly, even if you didn't have a proffer. But even more so, if you
Her rulings will be perfectly preserved. They will be perfectly preserved. Madam Mothman said, so basically a clerk can remove all the jurors they don't like as long as they don't deliberate, it doesn't count. That's a ridiculous stance. They don't deliberate, then it didn't affect the verdict, right? I mean, that's the arguments they're making here on why they can't talk about certain things. And Chuki said, exactly, this can happen to Murdaugh, this can happen to you. I mean, yes, is the short answer. Duncan, so this judge has no respect for the process and just wants to wash her hands of this. Murdaugh probably deserves to rot, but due process is paramount. I'm not going to say that about this judge. I'm hopeful she is. I think she's analyzing it, and this is where she lands. Nina, what's a courtroom proffer? That is a offer of proof. Offer of proof, where you basically, if they don't let you call a witness, a lawyer can say, Judge, this is what we expect the witness to say. And, we think it's relevant because this judge says, hearing what she would say or he would say, irrelevant, not coming in. And if the appellate court says, oh, no, Judge, based on what that lawyer said the witness would say, you should have let that witness testify. You were wrong. We're going to overturn it. So it's something that you put on the record like the witness testimony, but it's just a quicker version. It can be in writing. It can be the lawyer just saying it. It can be reading a deposition in. You can proffer evidence multiple different ways. All right. I'm going to jump ahead here a little bit in Poot's arguments.
all right, anything further before I go to the lawyers for the jurors? All right.
You're only one other point, and that is, you asked us to give you exhibits that we would use.
Yes, sir.
Having not asked or had the opportunity to ask Ms. Hill a single question, I can't tell you, in terms of, there's not thousands of emails we've used, probably 5.
I'm just going on some of the descriptions that were in the filings y'all have made to me.
Well, we've received thousands of emails from Colleton County, based on a subpoena we issued. We've received hundreds of pages from the AG's office in SWED.
It'll make it a lot simpler if it's a small number and a discrete number by submitting them to me. Again, I told you.
So common for judges to do this. Well, it'd be a lot simpler if you just had less. It's like, yeah, Judge, tell me about it. I wish I had less emails too. I wish this case was less complicated, but it's not. And I have thousands of emails, so I got to go through them. What do you mean? Of course, it'd be better if I had less, but I don't. It'd be better if none of this ever happened.
I would evaluate that when I get.
Of course, I don't think you can evaluate it until she testifies.
His argument here is basically, we don't know what we need until we hear what Ms. Becky says, because if she gets up there and says X, we may say Y is now relevant. The judge will let them talk about anything that's relevant, I believe, anything that's proper impeachment, I believe, but they're not going to let them railroad Becky Hill with all of her nefarious activities or allegations going on in the background. So we'll see kind of how much leeway the judge gives them.
I am going to do some evaluating before she testifies.
Okay, and Your Honor, she's given an affidavit denying making any of these statements.
She has.
So these alternate jurors that have been dismissed, would you allow us to call them to impeach her if that's what she testifies to?
At the present time, the answer to that is no, as I have indicated. But again,
And that is kind of wild. Now, if I'm the judge, I'm thinking the jurors who actually voted should be able to impeach her. So if we have those jurors impeaching her, if Becky Hill says, I didn't say any of this stuff, but the jurors say, yes, you did, then that's enough. And why do we need alternate jurors and the egg lady to come also say it? And again, this is a judge, not a jury. If it was a jury, I believe she would let more people impeach Becky Hill to make it clear. But I think at this point, the judge already kind of has her mind made up about what she thinks about the credibility of Becky Hill. I don't know what that answer is, but I think we're going to find out eventually. All right, let's jump ahead here for a second to Eric Bland and the lawyers for the jurors, who the judge said never has she seen lawyers for jurors or witnesses be able to take part in a hearing like this, which is what we all said and we all agreed with. But she's going to allow them to make a statement here if they have any more questions or any issues with how she said the process is going to go for their clients. We'll listen to some of it. I'm probably going to kick it up a little bit just because it's not a crazy amount of information, but let's get through it here.
All right.
May it please the court, Your Honor. Ronnie and I represent 4 jurors who rendered verdicts in this case.
I would like their numbers, but only if that doesn't violate the attorney-client privilege.
He doesn't end up giving her the numbers. I'm just going to skip ahead a little bit.
Remain, and that is not only because they voted guilty, if they voted not guilty, we would feel the same way. After hearing what Your Honor has established by way of procedures, we're very comfortable with what you have established to protect their anonymity and that they're not harassed. Ronnie came up with a good suggestion, maybe renumber the jurors 1 through 12. And that way, because there has been some public disclosure of the jurors' numbers in some of those emails, they were the big batch of emails that are put in reference. So maybe we cross-reference with the chart 1 through 12 and the juror numbers. But as far as the questioning goes, there's no need for us to be part of this. You're going to make the questions. You've indicated that you're going to preserve their anonymity.
Like, Judge, there's no reason for us to be part of this now that you've ruled on it. But Ronnie Richter makes some more comments about potential anonymity and how we can protect the jurors. That's basically their main point, but they're comfortable with what the judge has said. A quote of Green: trial court learns of an allegedly improper contact with a juror. The procedure of Remmer versus United States must be followed. Okay. Knox Foos: catching up to live isn't whether or not the juror's verdict was influenced by improper conduct as relevant as motive. The conduct is inconsequential. Why it happened and effect is irrelevant. Okay. Pesky Pirouette: Peter, if Papa T has some free time, would he mind drafting and codifying a juror's Bill of Rights at the federal level to protect all jurors' anonymity during, before, and after trial? Gosh, this bug is annoying me so much. Many thanks. Bev: Peter, since Judge Toll was a justice on the Supreme Court, knows her stuff, do you view her rulings today as anticipating an inevitable appeal? So my opinion is judges that go, the higher a judge goes, right? Number one, yes, they know the process. They know what to expect. They know how the judges discuss these issues in the higher courts, but they also are more confident in doing what they want or think is right more than other judges. So I find they have less fear of what's going to happen at the higher court. Netwoman: 20 more memberships. The memberships seem to be never ending in this live. So welcome to all the new members.
Anonymity, that they can't be photographed, they can't be on videotape, and that's about all we have to add.
Yeah, Your Honor, I would amplify that. I certainly respect and appreciate the significance of the issues that are before you. But let's just say in a hypothetical setting that because juror number 9 said something that you believe deprived Mr. Murdaugh of his right to a fair trial, you're going to grant a fair trial, a new trial. I would hate for there to be any mechanism for somebody to backtrace to who was juror number 9. Because I know the public has very firm opinions about this matter, and I wouldn't want that person to be subject to any kind of public scrutiny. So I would have asked of you that for the juror portion, that would be closed courtroom, that the press would be present, that their likeness, both voice and face, be muddled.
So he wants their voice and face to be muddled. That was basically the main addition Ronnie Richter wanted to throw on there for the jurors they represent. This is Mr. McCullough, who represents, we'll call him the Murdaugh-friendly jurors, and he's got some thoughts and comments, which I find interesting, his exchange with the judge as well.
Several of the things I was going to mention. One, Your Honor, was, of course.
How many jurors do you represent?
I'm sorry, Your Honor, I represent number 785.
This juror satisfies that juror regards your claim about that.
Actual seating juror.
That's the sitting juror.
It was removed at the end of the trial.
Oh.
Prior to the rest. Whoops.
Can you speak up, please?
You need to speak up some, Mr. McCullough.
I don't get that much, Your Honor.
Sorry.
Your Honor, if you will indulge me just a moment, I think much of what you said today bears on a quote that I'm taking from the response of the state, which was filed as part of your record. And my letter of November 10th responding to that filing is also part of your record. The state said that jury duty is this cornerstone civic duty. Needless exposure to jurors to litigative stress and impeachment by zealous attorneys in a case, especially this public exposure, can only serve to discourage citizens from willingly participating in this civic duty. Your Honor, I'm delighted with your ruling that you'll be asking questions. I've been subject to your interrogative skills in my appearances before the Supreme Court. So I'm pleased with that. I check that off the list. I would like, Your Honor, for you to take judicial notice that there have been excessive.
So a little butt kissing there, never hurt anybody. But now he's about to ask her to take judicial notice of some improper comments made by Creighton Water about the jurors. And let's hear what her response is.
Public comments by, and I have to say, Your Honor, in my letter of November 10th, I took Mr. Waters, who signed the letter, to task for labeling one of my clients, one of these jurors, as dishonest. I think I wasn't pleased with that. I think that discourages civic participation. I would ask the court to admonish the litigants, the attorneys.
Mr. Cole, let me stop you there. I am not aware of any of what you're talking about in terms of comments about jurors or otherwise. So that's just not something I'm gonna take into account. By listening to it or by taking any judicial notice of it, I don't know.
She's like, I'm not taking that into account. I'm not doing any of that. I'm not doing your bidding for you. I'm not going to tell somebody to shut up. A lot of public comments are being thrown around in this case on podcasts and YouTube channels and whatever it may be. She doesn't want to get involved in any of that.
But I would be taking judicial notice of it. I do not know anything about what you're talking about.
Well, Your Honor, both my letter and the response of the state are part of the record, which you obviously have not gotten to anything, but I would assume, yeah. My only request is I would admonish lawyers, officers of the court in this courtroom and outside of this courtroom, who represent people, to be cautioned that this is a search for the truth, not an effort to protect the verdict, nor an effort to discourage people from participation. Negative commentary doesn't, or runs the risk of doing it. That's all I'm saying.
I understand, and I decline to instruct or admonish participants in this procedure in any way about what you say.
Thank you. Your Honor, next, I'd like Mr. Victor and Mr. Bland, appreciate your efforts. I suspect that we will decline a ride to the courthouse, but I would ask the court to consider.
They talk about how the jurors are going to get there in the morning.
By not, or reconsider that no damage would be done to the right of the public.
So here is, and he said he wanted it, and in his experience, they've done it behind closed doors, in camera, in chambers. The questioning of the jurors, the judge said, I'm doing it in open court. But now we get to hear from Miss Becky's lawyer.
Your Honor, I'll be brief. In light of your rulings, I don't think you need much from me. The only thing that I'll add is I'll have Ms. Hill available for here at the parties need and happy to accept service to mediate one issue for this court.
I'll have Ms. Hill available as the parties need her, and I'll accept the subpoena on her behalf. So he'll have her available if the parties need her. Usually that means she'll talk with the parties. Does that mean she'll talk with Team Murdaugh?
Unless you need from me, Your Honor.
He's like, that's it for me, Judge. See ya.
All right, thank you for that, and before you leave the podium, let me just consult with the lawyers. I'm not going to ask them to examine you, that wouldn't be fair at all, but I'm going to ask them if there's anything else I need to inquire of before I let you go. Because I understand if the subpoena, and we would have formal subpoena of Ms. Hill, would be placed in your hands as her attorney, and you assure her appearance, and I appreciate that very much.
Absolutely.
Is there anything else on behalf of Mr. Murdaugh?
Your Honor, just in an effort to try to expedite this matter, I have two questions. One, will Ms. Hill meet with Mr. Griffin and I?
I'll evaluate that.
You'll evaluate it. Okay, that's all I can ask.
Will Ms. Hill meet with Mr. Griffin and I? That'd be really interesting because then they would know what they need to present. I don't know why she would. She doesn't have to. Why make their job easier if you're Ms. Hill? They're certainly not doing anything to help her. And her lawyer said he'll evaluate that. I would be shocked if that meeting happened.
And secondly, should we have her here on that Monday or wait? I mean, if you're going to be doing the jurors most of all
She
day.
should be here on as court reviews.
All right, thank you. That's from State, Your Honor.
All right.
Thank you.
I'll go with my checklist one more time, but I think I've covered everything I want to cover. I'll come to each of you in a moment. Yes, just to clarify other witnesses, as matters now stand, the witnesses in this proceeding would be jurors and Ms. Hill. So I want to be sure that we all understand exactly what's going on in that regard. I would not allow the attorneys to be called. I'm unclear about the mention in some of the papers that SLED investigators would be asked to testify, or any other witnesses. So I will go one more time. I want to get real specific so you will understand what you need to prepare for by way of in-court examination and what you need to prepare for by way of submitting properly. All right. First of all, for the defendant.
Please, Court, Your Honor, just a couple of issues. One, we don't know who we're going to call to impeach Ms. Hill. Because we don't know what she's going to say. So it's difficult for us. I mean, when she testifies, at that point, we say we'd like to call so-and-so and so-and-so and such and such and such and such, number one. Or maybe no one. I mean, she may concede every issue we have. For instance, she did tell, according to the state, she did tell one of her assistants, one of the people helping her, I hope you found guilty because it'll help book sales. Now,
I hope that's the last time you're going to repeat that until I ask
She's like, I really hope you're not going to repeat that again.
for it again, Mr. Harcourt. I told you that I can't imagine a situation in which I would go that far. So a statement like that, and she may well have said it, if it goes to anything I'm asked to consider, it would be to her credibility. And I'll evaluate whether I think that's even proper to ask, but let's move on from that.
but there are other questions concerning her credibility.
Yes, sir.
404 motive. If she did this, it is a crime. And so, the question of why she would have done this extraordinary act, and we can argue this at another time, but in terms of me, the reason I mention it is for us to proffer those people now, not knowing what she may that question may get asked, she may admit it. There's no witness that needs to be called. So it's difficult for me to game this out. I don't think I've ever been asked to list witnesses I would call to impeach somebody if they lie under oath. I've never heard of such a thing, but I will attempt to do.
I agree with him, but impeaching on collateral issues is not usually allowed in evidentiary hearings like this when the judge is making the decision. So it depends on how collateral the issue is. Like if she lies about something about her book, what does that have to do with her improper discussion with the jurors? Unless they can connect it, right? Unless they're saying like, you mentioned this in the book and it has to do with you talking to the jurors or what they were thinking at Moselle or whatever. But you got to connect it, right? I don't think she's going to let you just go into any collateral source just to impeach Ms. Hill's credibility at this point, because she even said, I think I can assess Ms. Hill's credibility just fine on my own.
As we would call prior to Ms. Hill's testimony. That's all I think I can do, if that makes sense.
It doesn't make complete sense to me because this is not the trial of Ms. Hill. And issues about motive and so forth and the possible commission of crimes are not what this inquiry is about. It is about her contact with any juror and what she said. So I will be treading very carefully with the deal of what you say about what you might or might not ask. But I am going to ask all the parties to be pretty specific with me about what I should be asking the jurors, and I can make a decision in advance as to what I am going to do about that, and what is going to be, at least by general topic, pursued with witnesses. And the reason I do that is because it gives me the opportunity to then consider what rulings I would make and move the proceedings along in an orderly way.
Well, Your Honor, maybe premature for me to note this was right, but we would accept your ruling on that.
All right.
Okay. Secondly, Mr. Murdaugh has been unable to review any of the discovery material in this case because of the confidentiality order prohibits us to distribute to him while he's in jail. We don't have time in the next less than 2 weeks to go sit down with him and review everything. Would Your Honor allow him to have, and the materials are not as to the evidence in the underlying case, it's as to jury issues. And while he's no longer a lawyer, he was a lawyer at one point and can evaluate this and be of assistance to us if he has an opportunity to review that material.
You're speaking to me about something in a complete vacuum as far as I'm concerned, so I can't really evaluate what you haven't been able to review with him and what you have been able to review with him. As I understand what you're telling me is I have received certain information as the attorney for defendant that I have not been able to show defendant for defendant's review because of confidentiality order. I can't imagine that. I think what you may be saying is Mr. Murdaugh has not been able to keep for himself while I'm not there confidential materials.
That's right.
That is something common to many folks who are under incarceration or limited in the kind of materials that they can receive and keep in their possession when they're not with their lawyer. This is not an issue where he's being deprived of the ability to consider material that you have received. This is a question of whether he can have that material in his possession when you are not there or your representatives are not there and study upon it and so forth. I can't control what the limitations of the Department of Corrections are, nor can I control what limitations may have been put on confidential material because of the fear that it would fall into other hands. So I might not rule in the abstract on things. I would have to have something pretty specific, but I can tell you this. I would certainly not order these materials be wholesale given to him for him to take back to his cell and have in his possession, because I don't know who might see them were that the case. And if they are confidential materials, that would be an extreme risk of breaching the confidentiality of the materials.
So this is a tough one for the judge because you want the defendant to be able to have these documents, to review these documents, to help aid in his own defense. But if they get into the wrong hands on this kind of case with juror information, that's highly problematic. So, I mean, I think there are ways in lots of jails to have the defendant guarded in a room where he can use a computer and review the documents electronically and they don't get out anywhere else. But I mean, she basically shuts it down. And I can understand from the lawyer's perspective as well as how problematic that can be if your client can't review these documents as part of his defense.
Do that because of his situation. His situation is as it is. Not my making or yours.
Your Honor, only note for the record this: much of the material we received has been within the last 2 weeks. This hearing is scheduled for 2 weeks from yesterday.
Yes, sir.
And you've given us more stuff we have to do between now and that hearing. There's no way to go sit with him at the jail and his time is limited as to when those people can visit. So without him being able to review this material, I don't believe we can be effective, and we'd be ineffective in representing him.
But I understand that those are wise statements for an attorney to make to preserve your position.
So he's like, Judge, if you don't let us do this, then we can't be effective in representing him, which is kind of like a threat from a lawyer. You're making me ineffective, Judge, by not allowing us to do this, or, the jail or whatever. And she's like, settle down. I understand those are wise statements for an attorney to make. It's like, yikes, 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 taking some shots there.
Position on record. It doesn't change my view of how we should proceed in this matter at all. I think you will be able to, if there are deficits in what you have been able to do with your client, you will place those contentions on the record, and the appellate courts of the state will have adequate chance to review.
Well, Your Honor, would you consider continuing the hearing on the 29th to allow us to meet with the client and effectively review the material?
No, sir.
Okay.
Thank you.
Would you consider a hearing or a continuance for this hearing? No, sir. It's like, okay. All right. Thanks for asking. Becky, what does this say to other clerks if Becky gets away with this? I think this was a rhetorical question. Shoot your shot for your shot at fame and money if you can write a book. Nefertiti, it is crazy how one person can screw up and screw over so many people's lives directly and indirectly, as family, friends, colleagues, clients, and now jurors. Wide-reaching ripple effect of Alec Murdaugh. Salty Beach Girl, Peter, I respect you so much. I disagree today, but respect you anyways, or respect you always. Thank you for always breaking it all down. No problem. And I'll just tell you, it's not unusual that people disagree with me if I see things in line, or if I think, legally speaking, the bad guy should win a legal argument. And Alec Murdaugh is a confessed, convicted, self-proclaimed liar and bad guy. I get it. He deserves what's coming to him. I get it. But the process really is what I'm looking at here, and hoping stays fair and just and appropriate. And so I'll just tell you, we're near the end of the hearing, but I'm getting the feeling Alec Murdaugh is going to lose this hearing. I do not think he's going to be able to show actual prejudice, that the jurors are like, yeah, absolutely, I was going to vote not guilty, but for what Miss Becky said. Now, while I think that's the wrong burden myself, this judge is more qualified than me. This judge has handled a lot more of this than I ever have, and she's a much bigger big shot in South Carolina than I'll ever be in any state. So her decision on the analysis to show that this actually changed the verdict, I think, creates a bar there's no way Alec Murdaugh's team can clear. And so then ipso facto, if we take that a step further, now we have a court clerk who wrote a book. I think the evidence is going to show that she did speak to the jury, had improper contact. She had contact and it was improper. I think the first two elements of this hearing are going to be met, but I don't think actual prejudice is going to be shown, the third element. But imagine having a clerk of court who's supposed to be a unbiased person working in the courtroom that the jury trusts and looks to as somebody that is going to be honest with them and help them and tell them where to go and help them order their food and be there to help them through the tough times of this trial, starts saying, don't be fooled by the defense, watch his body language, this person's lying. And to be able to know whether subconsciously that affects it or not, to have her hand openly in causing question marks from a juror who's ultimately removed with Facebook posts that can never be corroborated, and somebody whose verdict may not have been in line with her, or not at least in lockstep with her, potentially changing who the foreperson of the jury is and having a hand in that. It is just wild. I hate to think that this kind of a process is what we are going to just put our head down and keep trucking forward on, regardless of what you think about Murdaugh or Poot or Griffin or anybody. I just don't love it personally. I just don't love it. And I understand if you disagree with me, it's totally fine. A lot of you have said you disagree with me. You love the judge's ruling. You love the fact that Murdaugh's going to lose this and the conviction is going to stay in place. And I totally understand where you're coming from, even if we disagree on the outcome here. A couple unrelated comments here. Maria said, Judge and JHatch has a response to the filings out today. I'll have to take a look at that. Netwoman said, Peter, off topic, but Greg Anderson will be on RSDSA's YouTube page tomorrow at 7 p.m. Eastern, My guess is talking about those rulings by Judge Carroll, which I haven't seen yet. Okay, so let me know what you guys think. What do you think the outcome of this is going to be? Has your mind changed? Do you agree with it or disagree with it? Do you agree or disagree with me? Let me have it there in the chat. I love these discussions. I love to hear how you guys think about it. I love to hear the reasons you end up on one side or the other, because I think you all bring valuable and different backgrounds to the situation and to these decisions. And I think we learn a lot from each other. We have a pretty big chat going today. So if you guys haven't subscribed, please hit that subscribe button and let me know in the comments if you're new, first-time subscriber from this video. And make sure you hit that like button. Let's get it up to 5,000 likes here before you leave. We can do it if everybody hits the like button. I appreciate you guys so much. Stick around, because a wild kind of one-off video about a juror going to jail in Florida. We break it down. We break down why they ended up in jail, if it's going to ruin the jury system, if it's going way too far in our society today, or is this one actually warranted? I can't wait to hear what you guys think about this video. Misty Mathis, can the outcome in 2 weeks be appealed? Yes, this can all end up being part of the appeal. We'll see how much they get. All right. That's all I've got. I am out of here. Until next time, thanks for showing up. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.